Well, if I can just make a start again, and then on behalf of Doughty Street, can I welcome you all to this webinar. This is a tribute to Jonathan Cooper's life and his long work for the European Human Rights Law Review. It's sponsored by the European Human Rights Law Review and by our wonderful colleagues in OUTy Street who have organised this occasion. And before I introduce this special edition of the EHRLR and our speakers, I hope you'll permit me to just say a few words of tribute of a personal nature to Johnny. After Johnny's tragic and untimely death, messages and tributes flooded into our chambers at Doughty Street. Messages from those he helped, befriended, taught, inspired and championed. Lawyers and clients, young and old, gay and straight, from every continent and every walk of life. And those messages came from as far afield as Belarus, where he strongly stood up for the rights of opposition lawyers and for those exposing human rights abuses. His work there was both timely and prophetic, given the current tragic turn of events there and in Ukraine. And the messages came from Biafra too, where he was something of a hero for championing the right of Biafra to self-determination. They came from Chantal Day and Vicky Bush, the lesbian couple in the Cayman Islands, in whose case judgment has been given today by the Privy Council. Johnny took up their case right from the start, and thanks to his intervention, they now have the right to a civil partnership that had previously been completely denied. Though the Privy Council, disappointingly today, reversed the Chief Justice of the Cayman Islands' courageous earlier ruling that they had the right, in addition, the right to marriage. Messages came also from young students at Oxford like Richard Wagonlander, who will speak today, and from veteran human rights QCs such as the 80-year-old Lord Tony Gifford in Jamaica, with whom Johnny worked on the challenge to Jamaica's homophobic laws in the Inter-American Court. The messages have come from those he worked with at Justice and Liberty and at the Human Dignity Trust, where he was the first director and where he was the pioneer of numerous successful challenges to the criminalisation of gay sex throughout the Commonwealth. Truly, Johnny was ubiquitous in his influence and in his championship of the victims of oppression, persecution and discrimination. He was an inspiration to the young to get started in the cause of human rights and to the old to persevere despite all setbacks such as those today. And the tributes talked of the many wonderful qualities which he had. Francesca Klug recognized his many roles as lawyer, advocate, author, campaigner and trainer. She talked about the alchemy he worked by his combination of humanity and love of the arts, history and the law. As she said, to have Johnny on your side was to be bathed in warmth, encouragement, fun and love. Jane Ozanne talked to Pink News of his generosity with his time and his expertise and the work he did on banning conversion practices. Peter Lavrack put it in a yet more joyous and light-hearted spirit. He said, working with Jonathan was a great joy for so many, though often a hazardous affair if one was following him on a Boris bike from meeting to meeting. He obviously so enjoyed what he did, meeting the great and the good, cajoling policymakers and funders, writing in the press, strategizing and supporting those in need. It was all a way of life for Jonathan, not just a 9 to 5, and particularly if it could be done over several glasses of wine at the Groucho Club. But Johnny's legacy is not just in the many cases he inspired, initiated and guided, even when his contribution is not recorded in the law reports. It's not just in the law reforms he supported and championed, the Human Rights Act itself, the lowering of the age of consent, the better treatment of juvenile offenders. It comes most of all in his constant call to arms, which so many of us here will remember, his corralling and prompting and inspiring of others to take up the cause of human rights and fight for the rule of law and for the European Convention of Human Rights. and to take seriously the need to fight for the rights and freedoms of those suffering discrimination and persecutions on grounds of sexual orientation. Can I just remind you of Johnny's own words in an interview with Queer Lawyers of Tomorrow? He said this: "Whether we like it or not, we are part of a group who are persecuted. Our sisters and brothers across the globe are persecuted. It's important to remember that. We are part of a bigger picture and we need to support each other. We are part of a big global movement. And to be honest, whilst LGBTQ plus people are being persecuted across the globe, it undermines us all." Just to talk about his history and his wider impact a little more, Johnny did a pupillage with us at Doughty Street. I was his pupil master. I was lucky to be that. And he remained a lifelong member of our chambers after that. And he had lifelong friends and colleagues, such as Keir Starmer, whose tribute is contained in the special edition. He went on to do groundbreaking work at Justice and Liberty, and then the Human Dignity Trust. And as you know, he was engaged in a series of important challenges at the time of his death, fighting for the self-determination of the Biafran people, for human rights in Belarus, for the right to gay marriage in the British Overseas Territories, for the decriminalisation of gay sex, for the retention of the Human Rights Act. And with Helena Kennedy and others, he was, including Richard, who's here, he was fighting for a ban on conversion therapy. All this was infused by Johnny's boundless optimism and fearless willingness to tread where others dare not go. He was even part of an initiative to persuade the Pope to condemn the criminalisation of gay sex. And we still do have high hopes of the Pope, even without Johnny as ambassador. Johnny was not just a great lawyer, activist, friend, and mentor. He was also a luminous intellect, a true philosopher of human rights, and an encyclopedist of ideas. It was really reflected in his work as editor of the European Human Rights Law Review. He was there from the start, and over the last 2 decades was a constant presence, prompting, urging, and inspiring people to contribute. And this special edition is a true tribute to the range of his interests. So let me just mention some of those who contributed but will not be speaking. Konstantin Dzieciero of Belarus gives a somber but timely message that international human rights can achieve very little in a situation of crisis.
It's okay.
As he says,
oh, I've lost it again now. I've lost it now.
I'm so sorry. As he says, Johnny would not like this pessimistic article, but it's certainly profound food for thought at this terrible moment of history. Then there's the article by Rachel Marian Kingsley Kanu about self-determination of Biafra, which was another cause dear to Johnny's heart. I mentioned briefly Sigrid Rausing's article that saying he was a philanthropist in the true meaning of the word, and recording their trip through the night to Almaty in Kazakhstan, during which they sank a bottle of Uzbek vodka together. And finally, there's the article from Francesca Klug about his role in bringing about the Human Rights Act and his continued role in fighting for its retention. She also points out how he was the inspiration behind the Joint Parliamentary Committee on Human Rights. But now can I just turn to our band of speakers today, and any questions, can you put them in the chat? And then Oliver Lewis has kindly agreed to present them afterwards. So that brings me to Oliver. Oliver Lewis is a leading and brilliant member of OUTy Street with a long history of championship of human rights. He is also someone who Johnny often called on to contribute to the European Human Rights Law Review. So I'm going to call on Oliver first to speak on behalf of our colleagues at OUTy Street.
Thank you very much, Ed. Well, OUTy Street was founded in 2020 to give a focus on LGBT rights within chambers, and to ensure that our own chambers policies and procedures followed best practice and to shine a light on LGBT rights work within chambers. And Johnny was a core and founding member of OUTy Street. He organised many of our events. Many of you will have been there. We held 2 events just before the pandemic. And he was very keen to ensure that there was a focus in our work and in our mission on the rights of trans people, which was very important to him. So within OUTy Street and OUTy Street, he remains a national treasure. He would hate me to say this, but he was our daddy. In terms of the European Human Rights Law Review, he was always so encouraging to everyone who wanted to contribute, but in particular to early career scholars. As encouraging he was to them, he was intolerant of nasty reviewers and always irritable with people who sought to, in an academic fashion, bring others down rather than raising them up. I think that he always brought out the best in authors. I can certainly say that he brought out the best in me. And each time I published with him, he would always give me really cracking feedback, saying things like, Oliver, I want your piece to be the go-to paper on this subject. He made me feel important. He encouraged me to be the best scholar I could be. And I know that my experience is shared by many others. He, I think, would be thrilled and embarrassed in equal measure by the special edition. I miss his random phone calls at all times of the day and night, asking me to do something or passing on a piece of titillating gossip. I miss his wit and wicked sense of humour, even more wicked with wine. I miss his way of explaining complex areas of history or law in a simple way, but never dumbing down. I very much miss his principled way of thinking, the way that he inspired others to think, but also to take action, and in a sense, his lifelong mission to right wrongs. Most of all, I really miss his friendship. I miss his hugs, and I miss his gloriously sloppy kisses. Thank you.
Thank you very much, Oliver. And as you say, Johnny always brought out the best in all of us. And now, can I move on to Stephanie Palmer? Stephanie is an associate professor at the law faculty at the University of Cambridge, where she teaches courses on human rights and constitutional law. Her current research projects include working on a book on human rights in the UK and a research project on gender and climate change. And she's going to speak to us about Johnny's long-standing work for the European Human Rights Law Review.
Thank you. Well, thank you very much, Ed. And thank you also to OUTy Street for inviting me to talk at this tribute. So I'm one of the new editors of the European Human Rights Law Review, along with 2 colleagues, Kirsty Hughes and Stevie Martin. And we are honored to continue the work, of Johnny. And I think he would have been delighted to know that it's taken 3 people to replace the work that he did. And I'm certainly also beginning to understand why I would get these late at night phone calls from Johnny saying, please, can you review this? I need it by tomorrow. I used to think, oh, that's a bit annoying and not much time, but I'm beginning to understand the urgency as I have taken on this role. The special issue is something for which actually the new editors cannot take credit. This was carefully and beautifully crafted by members of the editorial board. And I think it's a really fitting tribute to Johnny. And I think, as the previous speaker said, he would have been touched, but also maybe also embarrassed. But it is, I think, a truly fitting tribute. And we as the new editors are really committed to ensuring that the outstanding quality of his work and the values, enthusiasm, and encouragement that underpinned his practice and his dealing with people in the journal are preserved. And certainly I was one of the people who he really encouraged to publish, and it does make such a difference. And believe me, it is quite a rare thing in the academic world. And one of the special features of this journal, which was no doubt due to Johnny, is that it does have contributors from not only academics, but also practitioners and judges and other people involved in human rights work. And that, I think, makes the journal really special. And we really hope that that will continue, especially as this is a crucial time for the human rights community and the journal as well, given the government's proposals to recast the Human Rights Act, as well as, of course, the other bills before Parliament that show a distinct lack of respect for human rights. And our first issue as new editors will be out in a few weeks. And I'd just like to tell everyone that about one article in particular. It includes a wonderful speech by Paulo Sergio Pinto de Albuquerque, who's one of the judges on the European Court on Human Rights, who has specifically dedicated it to Johnny. And I'd like to read to you what he says. He says, the speech is dedicated to Jonathan Cooper, a true believer in Europe and a committed human rights jurist. May his legacy remain as an example for all those striving for a greater unity between European nations and for the maintenance and further realization of human rights everywhere. So this is a wonderful tribute and quite a poignant tribute, especially as this speech was actually delivered in September last year in Kharkiv in Ukraine. So I would very much hope that as the journal has been so closely associated with Doughty Street for at least the last 20 years, while Johnny was the editor, that we would very much like to keep that close connection. And so thank you very much.
Thank you very much, Stephanie. And in tribute to Johnny's great work, I think we'll all commit ourselves to at least submit a copy to try and support this wonderful publication. And
Yes,
and now, if I can now turn to Kevin. Kevin, as you all know, was Johnny's husband. He is a writer and lecturer on art history and the history of visual culture, and he has also developed a series of pieces looking at the contribution to culture and history made by LGBT people over the millennia. He is the author of a wonderful tribute in the special edition. And I'd just like to call on Kevin to speak about Johnny's life and work from his more intimate perspective, from his inside knowledge of the man and his spirit.
Thank you, Edward, and thank you for asking me to be on this panel, which is very august. I feel, as a non-lawyer, I feel sort of, anyway, I don't know what I feel. I thought a lot over the last few months about where Johnny's commitment to human rights came from. And I think it's ultimately riveted in discrimination, his own feeling of being discriminated against as a teenager and a young man, as a gay teenager and young man in the 1970s and in the 80s, the early 80s at least, that almost constant fear that we all had, I suppose, of being gay bashed, of being othered, of being isolated. And it's really unfair. And I could see why he would feel that quite deeply himself. And then that discrimination becomes much broader when you start to think about it. And believe me, one of the things Johnny did was think about things against LGBT people in general, particularly discrimination through the law. Back in the day, the laws of gross indecency, the unequal age of consent, Section 28, of course, and various other laws, even the lack of protection in the law for, you could be easily sacked from your jobs, you could be thrown out of your house, all sorts of things could happen to you just because you were gay or trans. And then the third aspect of discrimination was discrimination against people living with and indeed dying from HIV/AIDS. His first job out of university was the AIDS coordinator, the HIV/AIDS coordinator of the Haemophilia Society. And that in a way gave him a sort of broader definition of living with HIV and AIDS, because he was working specifically on the problem with blood products that had been infiltrated with HIV being given to people with haemophilia. But also he was then in contact with a lot of other people who were working in the sector too, and they gradually together they started to formulate this idea that there's something terribly wrong about the response to HIV. People are being stigmatized, awful things are happening to them, they have no rights. And he recognized that something needed to be done. He also recognized that the law, as well as being an instrument of oppression, could also be a tool for protection, for protecting rights. But as he would have in conversations at the time around 1990, this was even before I met him, how do you do it? I met Johnny on his first day at bar school back in October 1991. And he claimed he fell in love with me immediately. I cannot claim the same, but it happened soon after, let me put it that way. Becoming a lawyer, and specifically a barrister, for him had nothing to do with the processes of running a case or going to court. He rather hated all of that, in fact. As I'm sure Edward could tell you, the last thing he wanted to do was go to the magistrate's court or anything like that. In fact, he rather despised it. And everything to do with being, everything to do, what he felt he wanted to do was what is now being called in a slightly sneering way an activist lawyer, which is what he was in his bones, really. And in order to be an activist lawyer, he had to understand every aspect of the sort of law he wanted to use in order to effect change. The law, yes, but I would also say in order to change hearts and minds, because one of the things that Johnny always said was advocacy was all very well. It was a great thing and very important. But perhaps more important was the idea of communication, to communicate what human rights mean in terms of protection, to persuade people that the right to dignity, for example, was essential to human happiness. You had to know what you were talking about, and therefore he had to make himself an expert on human rights law. And that combined with his passion for people, not just for causes and not just for LGBT people or people with AIDS or whatever. It's all people fascinated him. Anyone who ever met Jonathan was entranced by his love of people, I think. And when you were talking to him, you were the most important person in his orbit. I always felt that. So it's that kind of passion drove him to take on all of the cases and causes that occupied his time over the 30-odd years that I knew him. It's what made him almost perfect. I don't say perfect because I've always thought perfection was rather dull, and one thing Jonathan was not was dull. I remember I would sort of tag along on some of his trips, for example, to St. Petersburg, where we were invited to this reception at the British consulate there for judges and advocates and things like that. And I was so inappropriately dressed. Immediately afterwards, all of his training of judges, advocates, and police was cancelled by the incoming Putin government. And he said, it must have been because of your gold corduroy trousers. I don't think it was, but he may have been right. And another occasion when we were in Jamaica, and this shows his bravery, really, checking into a hotel. They were determined to give us a room with 2 single beds in it. Johnny was not going to have this, and this is Jamaica. You know, it is illegal to have any kind of sexual intimacy between people of the same sex in Jamaica, and he was not going to have this. He wanted at least a king-size bed, or at least a queen-size bed. I managed to find a deep interest in the potted plants in the foyer while he was arguing with the management over this. But eventually, their solution was to upgrade us to the presidential suite in the hotel, which had the largest bed I have ever seen in my entire life. I think the idea being that there is no way we would ever find each other in the night as we tried to crawl across this gigantic bed. Anyway, that was Jonathan. He was very brave in his advocacy of these things. And I think recent developments that have happened since he's died in Ukraine, developments in Biafra too, and today this insane decision by the Privy Council to deny same-sex couples in Cayman and Bermuda the rights enjoyed by same-sex couples here. It makes no sense to me, and it's sort of, to my mind, it's a decision tantamount to green lighting nasty regimes around the world to discriminate against people they hate simply by changing their constitutions, amongst other things. All of these things Jonathan would have been advocating passionately for, or indeed against, long and hard until somebody paid attention, even if it was just being on Twitter. But it would be a lot more than that. He would be bombarding people with emails until something actually happened. Now, that torch has to be passed on. Sometimes I feel he's passed it on to me in certain areas. Sometimes I feel that torch has got very hot in my hand. And also, it's very lonely being a long distance runner. And everybody needs support in carrying that torch, which is why Jonathan was always there for people, not just as a lawyer and an advocate, but as a friend too. He was always willing to help. He was always willing to give his, not just his time, yes, but his expertise and also his love in order to help those people go through these very long, very often extremely long processes in the law, etc., in order to maintain, in order to profess their rights. So I commend this wonderful publication, and I thank the EHRLR for marking Jonathan's contribution to the world of human rights in this way. I really don't have anything more to say about it. Thank you very much.
Thank you so much, Kevin, and thank you for speaking about the well springs of Johnny's activism and his incredible gift for communication, and as you say, he would have been passionate in his condemnation of what's going on in all those ways. Now, can I now move to Paul Johnson? Paul is Executive Dean of the Faculty of Social Sciences at the University of Leeds, and his, oh dear, there seems to be an echo. Oh, Paul, can you, yes, and his research focuses on LGBT human rights. Paul worked with Johnny on many important cases, including the gays in the military case and the case of HC in the European Court of Human Rights, about which he writes in his article. So can I invite Paul to speak about his article, The Love of Law and the Law of Love?
Thank you, Edward. Thanks very much. And thank you very much for inviting me to participate in this event to mark the publication of this special issue. This special issue is very special indeed, given that it celebrates the life and work of this wonderful man who was the editor of the journal for over 25 years. Conor McCormick, in his editorial to the special issue, sums up, I think, in one perfect paragraph, what made Jonathan special to many of us. He was, says Conor, the most complete human rights advocate any of us have ever encountered. And I think that's very true. The special issue also shows that for many people, Jonathan was not only the most complete human rights advocate, he was also, as Keir Starmer puts it in his achingly beautiful obituary, a complete one-off. And for many of us, what made Jonathan a complete one-off was, as his husband Kevin so movingly just told us, was that he continually combined a deep love of people with his deep love of law. And that is what I tried to show in my contribution to the special issue, how Jonathan's love of law was born from his love of people and his deep desire to protect the human dignity of all people who are discriminated against in society. And in my article in the special issue, I focus on Jonathan's work in advancing the human rights of LGBT people before the UK courts and the European Court of Human Rights. He had a long history of doing that. I provide in the article an examination of 3 cases in which Jonathan acted as an advocate and 1 case in which he intervened as a third party. And I chose these 4 cases because, in my view, they demonstrate important aspects of Jonathan's approach to law, and in particular, his approach to using human rights law as a means of expanding the legal protections for LGBT people. The 4 cases I discuss in the article span decades. They start with Jonathan acting as an advocate for Graham Grady in the Court of Appeal in the mid-1990s, Mr. Grady being one of the applicants in the cases that went to the European Court of Human Rights and resulted in the end of the ban on gay people serving in the armed forces. I also discussed the little-known case, hardly ever remarked upon, of Margaret Fleming, who Jonathan advocated for before the now defunct European Commission of Human Rights. Ms. Fleming was the civilian partner of a servicewoman, and she was subject to the most horrendous degrading treatment by the service authorities because she was having a relationship with a person serving in the armed forces. And Jonathan really got behind her case and took it up. I also discussed the case of Mr. H.C., who Jonathan represented in the European Court of Human Rights, which resulted in the decriminalisation of same-sex sexual acts in Northern Cyprus in 2014. And the 4th case I discuss is the most recent, and it is a very well-known case. It is the so-called gay cake case, which is a silly designation because, as Jonathan would undoubtedly tell us if he was here, the case is not really about a cake, but about the gay man who tried to buy it. That gay man is Gareth Lee, and the essence of his case is fairly simple. Mr. Lee went into a bakery in Belfast and tried to buy a cake using the icing service that was on offer, iced with the words "support gay marriage." The bakery refused to supply the cake on the basis of an opposition to same-sex marriage founded on religious belief. Both the County Court and the Court of Appeal found that Mr. Lee had suffered discrimination on grounds of sexual orientation contrary to the law in force in Northern Ireland. But the UK Supreme Court overturned that finding, holding that there had been no unlawful discrimination. The judgment of the UK Supreme Court absolutely incensed Jonathan. He regarded it as a profound breach of the legal defences against discrimination that gay people had fought so hard to secure. He wrote several strongly worded public pieces condemning the judgment and felt incredibly motivated to get involved in the case. And on the basis of that, Jonathan and I collaborated as third-party interveners in Mr. Lee's case in the European Court of Human Rights, a case very ably overseen by Mr. Lee's representative, Kieran Moyner, who is a leading light in advancing LGBT legal rights in Northern Ireland. In essence, what Jonathan and I told the European Court of Human Rights was that the UK Supreme Court had failed to uphold the law in Northern Ireland that was expressly designed by the UK Parliament to protect the human rights and human dignity of gay people. And Jonathan was very motivated to tell the European Court of Human Rights that the UK Supreme Court had failed to sufficiently consider Mr. Lee's human rights and, moreover, as Jonathan put it, trivialised his human rights. As I finished working on the final version of the piece in the special issue, days before the editor sent it off for printing, the European Court of Human Rights issued its decision in Mr. Lee's case, declaring the application application inadmissible on the grounds that Mr. Lee had failed to exhaust domestic remedies in the UK courts. The essence of the European Court of Human Rights decision is that Mr. Lee had not sufficiently argued his convention rights in the domestic courts and therefore had deprived the domestic courts of ruling on this. When I read the decision, I really longed to discuss it with Jonathan. I can only imagine what he would have said. I know he would have absolutely condemned it. For me, the decision is entirely problematic because, as we explained in our third-party intervention, and as I explained in the article, it sort of blames Mr. Lee for what Jonathan, rightly in my view, saw as the UK Supreme Court's failures and places unfairly the blame on Mr. Lee. So I really regret not being able to talk to Jonathan about it. Can I end by saying that Jonathan's lifelong legacy to me, and I think to all those who knew him, was his profound commitment to human dignity. No matter what he was talking about, he continually returned to the concept of human dignity. It underpinned everything he engaged with. And I opened the article with the words of the great American poet, Mary Oliver, which I think Jonathan would have liked, and they touch upon human dignity. And I'll end with these very few words, if I may, of Mary Oliver. She says, "I would say that there exist 1,000 unbreakable links between each of us and everything else, and that our dignity and our chances are one. We are at risk together, or we are on our way to a sustainable world together. We are each other's destiny." Thank you very much.
Thank you very much, Paul, for that wonderful explanation of the cases and above all of Johnny's philosophy. And I remember his passionate commitment to the concept of human dignity underlying everything. Next, can I call on Richard Wagonlander? Richard, I think I'm right, you're still a student at the university, but you worked for Johnny as a legal researcher assistant on various cases, and that included your work on the initial draft of what would later become the Cooper report. And you're going to speak to us about the government's proposals on banning conversion therapy and your work with Johnny on that. I'm very grateful to you for coming.
Thank you so much, Edward. One of the things that made Jonathan so special and his loss so heartbreaking was the inspiration and impact he had on younger people who were still in their early legal career steps or still studying law, such as myself. He's also the reason that I had the confidence or overconfidence to submit this submission to the European Human Rights Law Review, which so fittingly touches on a topic that we worked on together. My article, as Ed hinted, discusses the government's recent proposals on banning conversion therapy, a practice which, broadly speaking, seeks to change, suppress, or cure an individual's sexual orientation or gender identity. I think one thing that article seeks to highlight are Johnny's immense contributions to what would later become the Cooper report, rightly named after him, a set of legislative proposals on banning conversion therapy, which has had a profound impact on the government. For one, the government broadly adopted the approach in the Cooper report, combining criminal and civil law remedies, as well as support services for victims, the restriction of promoting conversion therapy, and sentencing uplifts, all proposals that we had been working on together. Sadly, the remainder of the proposals is not quite as convincing, as the government will not ban talking-based forms of conversion therapy for adults where informed consent is provided by the recipients. This, in addition to issues around the inadequate definition of conversion therapy the government has kind of put forward, is the main focus of my article, and I would just like to highlight a few broader points. Firstly, I underlined that the informed consent exception is rightly regarded as a loophole with the potential to undermine the entire thing. Physical forms of conversion therapy already fall within existing criminal offences, and the bulk of what actually needs addressing are precisely talking-based conversion therapy forms or conversion practices, which are as or even more harmful to the well-being of recipients. Some might read the government's proposals and think, there will be a power imbalance in most of these cases, severe social or family pressure, where these practices still occur. So the proposals could, in theory, work very similar to a full ban. I think that's misguided, which I argue in my article, as the exception will actually place a far higher burden on victims to not only prove the respective act and intention of the offender, but also a lack of consent, and all that to a criminal standard. The proposals seem to imply that conversion therapy will be close to eradicated, except in the few cases where informed consent can clearly be established. But I think it's actually going to be the opposite. A profound worry is that the exception could lead to so-called healers requiring patients to sign liability waivers, which explain the risks, whilst verbally still reassuring the success of the unscientific treatment. Proving a lack of consent retrospectively will be very hard, with victims fighting an uphill battle to achieve minimal justice. The issue is compounded by the standard of consent, which I touch on in a further section, which is supposedly going to be the section 74 of the Sexual Offences Act 2003. I highlight that this section would not provide robust protection for victims, as the government has stated, as the case law on this test does not find that every kind of deception actually vitiates consent. For instance, in Aaron Lawrence, the Court of Appeal found that deception as to the risks or consequences rather than the performance of an act does not necessarily vitiate consent. Now, how would this test work in the context of conversion therapy? I mean, no one really knows. Though what has been observed in sexual offences cases would suggest that it would heavily depend on the judiciary, and even more so on the discretion and prejudices of juries, which, given this concerns a minority group, is particularly worrying. The article then touches on the proposal's inconsistency with general English law on harm and consent, which takes up its own whole section. And to provide a snippet, if the informed consent exception passes, we would be living in a country where sadomasochism and bodily modification are criminalized and cannot be consented to, even though evidence of these practices' impact is sparse. But you can still consent to a pseudoscientific practice clearly harmful to a minority group with protected characteristics. So that's just an example showing how ridiculous the outcome would be if the informed consent exception would pass. The last sections mainly deal with the European Convention on Human Rights, which I argue the government got quite wrong. Given the overwhelming evidence of the adverse impact of conversion therapy, which the government itself has acknowledged, there's a compelling case that the informed consent exception breaches the convention, prohibiting provisions prohibiting inhuman and degrading treatment. The balancing of rights the government conducted, to summarize, is misguided, as it seems to suggest that freedom of religion and other freedoms can be balanced against Article 3, which prohibits degrading and inhuman treatment in absolute terms. In this context, I argue that the UK could potentially be breaching its positive obligation to set up an effective system deterring and punishing acts of ill treatment, particularly relevant in the case of marginalized minorities. This is especially because the proposals could actually institutionalize and legitimize these practices. And I think all of this is especially frustrating given that the government accepts that talking forms of conversion therapy are harmful, unscientific, and illegitimate. But because of religious persons' supposed right to support from religious leaders, an informed consent exception is justified in these proposals. So the same practice viewed as harmful and illegitimate in one sentence is described as part of a right to religious support in another. And we can only hope that the government reconsiders this approach in the coming legislative process. Jonathan had been deeply disturbed by the fact that it had taken so long to even discuss a ban, which combines all the characteristics of being discriminatory, deceiving, and harmful, and an affront to individuals' dignity into one specific practice. Indeed, courts all around the world, including the South African Court, the Supreme Court of Canada, and the European Court of Human Rights, have recognized the severe psychological harm discrimination can have on individuals. So why is the UK government struggling to recognize the severe psychological harm of talking-based conversion therapy, which is arguably far more detrimental to its victims than a one-off employment discrimination? I hope this gives a helpful overview of some of the areas the article touches on and sparks some interest. And you can find the Cooper report, which Jonathan helped supervise and draft online, published by the Uzan Foundation. Thank you so much.
Thank you very much, Richard. It was really profound and searching, and I thought it was a brilliant article that you wrote. Thank you, and for your tribute to Jonathan. Can I now move on to Dr. Leonardo Rasnich? Leo is a brilliant academic and advocate for human rights across the globe, and he has a special expertise in LGBT plus people in the Caribbean and the rights under the constitution there. And he's going to speak about the battle for decriminalization and for the right to marry in the Caribbean. And obviously, Leo, it's particularly timely given the massive part that you played with Johnny in the Day and Bush case, and given today's judgment, which has already been said by Kevin, is deeply disappointing. Leo, thanks very much for joining us.
Thank you very much, Edward, for your kind words. Thank you for inviting me to this meeting today. I met Johnny particularly precisely in relation to the case for which judgment we got today from the Privy Council. I approached him with Chantal and Vicky 5 years ago to start the process that has culminated today. At that time, I was also working in the Caribbean region, researching the impact of criminalization and discrimination on LGBT people in the American human rights system. I did a research with then a judge of the Inter-American Court of Human Rights, Raul Zaffaroni. The results were published last year. One aspect of the result of 5 years of research sponsored by the International Bar Association was that we detect that there was an anomaly in the continent, just to put it in simple terms. And I tried to show that in the map behind me, that the audience can see. Everywhere that is green, light green, turquoise, if you want, are countries where LGBT rights are progressing or are actually arrived to full equality. So you can see that there are 35 countries in the American continent, of which you have 3 in North America, Canada, United States, all have same-sex marriage. Mexico also has same-sex marriage. There are 21 countries in Latin America, Central America, which are part of the Inter-American Court of Human Rights system, which are obliged under the convention to open same-sex marriage. 4 countries English-speaking in the Caribbean, which have renounced the Privy Council and have accepted the jurisdiction of the Caribbean Court of Justice. They are very slowly moving towards decriminalization, and more likely than not, if the case comes, they will have to consider same-sex marriage. But the importance of the Caribbean Court of Justice is to have endorsed the importance of human dignity in order to enforce constitutional clauses, and in order to read in the Constitution the importance of equality for a society, including LGBTI people. And that was very clear when they decriminalized transgender people in McEwan versus Guyana in 2019. That is leaving us with 8 countries, which still are keeping the Privy Council as the final court of appeal, and more than 12.5 of overseas territories, which belongs to European countries mainly, although there are some territories under the United States as well, which are not countries, but they are territories of those countries. When we look at the overseas territories, particularly the European ones, but also the American, LGBT people have achieved full equality in those territories. whether they are Dutch, French, or American, or Danish, LGBT fully equality has been achieved in those territories. The only one where there is no rights hardly at all are the British overseas territories in the Caribbean, whose last court of appeal is the Privy Council. And when it comes to the 8 independent countries that have kept the Privy Council as the final court of appeal, 7 of them still criminalize LGBT people. So one of the conclusions of the research based on this is that the Privy Council's decisions were actually hindering the progress of LGBTI rights in the jurisdiction. And what was problematic for us was the decision of the Privy Council in relation to Trinidad and Tobago in 2007, in that the Privy Council acted endorsed discrimination on grounds of sexual orientation, reversing a unanimous Court of Appeal of Trinidad and Tobago that had found that a particular law was unconstitutional because it was a breach to the equality principle of the Constitution, because it excluded from the protection of the law peoples on grounds of sexual orientation. The Privy Council in Surratt versus Trinidad and Tobago, by a majority, a split judgment 3-2, overturned the decision without even addressing the issue of discrimination that has been decided unanimously by the Trinidad and Tobago Court of Appeal. But the other point that, and which is the essence of the article that I published in the review in memory of Jonathan, is the so-called saving clauses cases, of which there is a trilogy of cases that come from 2004, from cases originated in Barbados, Jamaica, and Trinidad and Tobago. Boyce, Matthew, and Watson. In essence, in those cases, the Privy Council held that the General Saving Clause provides absolute immunity to all colonial laws from any constitutional challenge, regardless, and I'm quoting here Lord Hoffman's words, regardless of how inhuman or degrading those colonial laws are. Lord Hoffman then went to say that that immunity is absolute, is complete. The Privy Council was not just extraordinary, reversing itself, because a year earlier they have actually arrived in Rodal versus Trinidad and Tobago, a completely different outcome, one that actually makes the savings clause still have a role in the constitutional framework, but at least it reduced its absolute shielding of colonial laws as it was decided in this trilogy of cases, to basically suggest that the court has the power to construe those laws as far as it was possible in a way compatible with the Constitution, where the saving clause did not allow us to invalidate those laws. That decision was reversed. Now, since those cases were decided, the Caribbean Court of Justice have to face this, particularly for Barbados and Guyana. And the Caribbean Court of Justice in 2018, in the case of Narvaez, decided to reverse the Privy Council, stating that that decision was incongruous, frustrates in perpetuity the constitutional supremacy and independence of the judiciary, and is an unacceptable diminution of freedoms. Now, this case deals with mandatory death penalty. So the question you may be wondering is, well, what do they have with LGBT rights? Well, the reason why this is important to LGBT rights is because, as the Attorney General of Trinidad and Tobago said in July last year, there are 18 laws in Trinidad and Tobago which are colonial and discriminate against people on grounds of sexual orientation, including criminalization. So this is the second reason why the article concludes that the Privy Council is not only endorsing discrimination, is in effect perpetuating criminalization of LGBTI people in the jurisdiction under which it has final say in the Caribbean region. Just to finalize this, I mean, the Privy Council has sat and heard in November last year arguments to revisit this trilogy of cases. They have an opportunity to move away from what is clearly, at the moment, their predilection to enforce the worst of European colonialism in the continent. They are the only court of appeal. I'm not holding my breath because today, in the judgment of the Cayman Islands and Bermuda, they have actually recreated segregation of people in the Caribbean, something that the continent has not seen since 1896, when the United States Supreme Court brought about the doctrine of separate but equals and created segregation on grounds of race, which lasted for almost 50 years until in 1954, the same Supreme Court reversed that doctrine in Brown versus Board of Education. The decision of today is absolutely shocking that in the Caribbean, we still have a court with foreign judges from London who are actually imposing segregation in the case of Bermuda against the unanimous decision of every single judge that sat in Bermuda and concluded that that could not possibly be read in the Constitution of Bermuda. It is rather appalling what happened today. I think Johnny will be extremely upset with that decision. It's not just devastating, it's devastating for British barristers as I am, that we have those top judges who actually are failing to understand a basic concept of human dignity embedded in a written constitution passed by the UK Parliament, not by foreign powers. It is the UK Parliament. They have said today that the UK Parliament, in passing the Constitution of the Cayman Islands in 2009, endorsed segregation. Thank you very much.
Thank you very much, Leo. It's a profound question whether the Caribbean would now be better off with the Caribbean Court of Justice than with the Privy Council, given these recent rulings. But anyway, perhaps we can discuss that afterwards. Finally, is Madeline Rees with us?
I am.
Oh, wonderful! Thank you, Madeline. I'm so grateful. I know you've had some difficulties in joining us just before, but we're very, very grateful. Madeline specializes in discrimination law and has worked on behalf of both the Commission for Racial Equality and the Equal Opportunities Commission. And she began working in 1998 for the Office of the High Commissioner for Human Rights as the gender expert and head of office in Bosnia and Herzegovina. And she talks about that in her article. And then since 2011, she has been Secretary General of the Women's International League for Peace and Freedom and was made an OBE for her work on human rights. I know that Madeline and Johnny worked together on the case in the military case, and that she has written about the importance of his battle for the right to gay marriage and his profound belief in the concept and need for human decency, human dignity. Madeline, can I gratefully invite you to speak now?
No, thank you. And I have been able to listen to nearly all of the interventions. So I think Johnny would be very happy to listen to the anger and passion about these recent cases that are going in the wrong direction, but completely, but also to know that we're still here, we're still doing it, and nobody's going anywhere until we have actually completed what we need to do. And I think that's the thing that's come out all the way through for me listening to you, but also previously is the completeness of Jonathan. The absolute completeness of him as a human rights advocate. It was in his DNA. And it's what you said, Kevin. His love for people meant he really understood us, and he understood us in our totality, so he could actually see when something was wrong. He knew what that harm was and what we needed to do to address it. And that's why I think he was so ahead of his time. I was really pleased to be asked to write for the edition, although I was terrified at doing it. And as most of you who were on the editorial board know, I was slow because I didn't know what to do. I mean, how do you try and capture the essence of someone like Jonathan Cooper? You know, he was so huge in all our lives in different ways. And you know, I wanted to express my experience of him, not just the legal cases and the brilliance of his mind in addressing those legal cases, but how, again, it was the totality of his understanding of what it was we were trying to do. So it took me a long time to try and get it down. And I talked every night to him as I took the dogs for a walk, asking him, what did he want? What did he want me to say, you know? And then I did write something, and all but the first paragraph of it disappeared. So I think even then, you know, he's providing guidance. And it can't disappear off a computer, but totally, mine did. Providing guidance, because clearly what I was putting down was not what it was that was needed. So I didn't go into the details of the cases because I think there's no need. They speak for themselves. They speak for what Jonathan was pushing for and helped to guide us towards. And it was always, always with Jonathan, teamwork. You know, he was the guiding hand. I think it's just amazing. You can see he's the hidden hand behind so many different things. And he was in my life. Even when I was in Bosnia, as I mentioned it in the article, there was many difficult cases under international law and human rights law, cases of rendition, cases which really got to the core of ethnic discriminations, plural. And he was always there. He was always there to help, to guide, to be the unseen person behind giving me that expertise and advice as to how to make it work. So each time I sat down to write, I mean, every single paragraph, I just recall his incredible giggly laugh and his warmth and enthusiasm for it, and his wicked wit, his absolutely wicked wit. And that enthusiasm and passion, it comes through all the time. His brilliance and his understanding of what we need to do to make change. And I say, just look at us, we're still here, we're still going to do it. One step forward, two steps back, but we're going to get there because I absolutely believed in his vision that we will understand each other better one day. And then we can be kinder and gentler in the way that we actually address the totality of a person. And that would be what Jonathan would want us to do. So I'm very pleased to see everybody here and to be part of this. And thank you, Doughty, for hosting. And love to you, Kevin. I have to say that your intervention at the memorial was just so moving and brilliant. Thank you.
Thank you very much, Madeline, and thank you for your wonderful words and for your article, which is really inspiring and moving. Can I now pass to Oliver to field the questions, and perhaps Oliver, you may say some words of final summing up at the end if you wish to.
I'll leave that to you.
Okay, fine. Okay, fine.
In the meantime, there are several questions, probably quite easy for maybe Stephanie to answer, as to how can people attending tonight get a copy of the special edition if they don't. It may surprise you that there are people who don't subscribe to the journal, but how can they get a copy of the special edition? Oh, you're on mute, Stephanie, sorry.
Yes, well, you'd think that would be very easy for me to know, but as I've only been the editor for a few weeks, I'm afraid I really don't know the answer to this. But what I suggest, if somebody in Doughty Street could collect the names, I will certainly contact the publishers tomorrow. And I think it would be a wonderful idea to have it as a separate, as something separate from the rather than just as part of the as a part of the total whole year deal. So I will certainly make inquiries.
Thank you very much. So if people would like to know the answer to that, maybe you could email the Doughty Street events team, and we'll let you know afterwards. Right, there are several comments by people who, like everyone who's spoken, absolutely adored Johnny. People saying that he was also committed to women's rights. He understood and wanted to draw attention to women's rights, and that he was concerned for all forms of human rights oppression, which has come out, I think, from the array of speakers and array of topics. other questions or comments? Margaret's mentioned his concerns about the unlawful kidnapping and rendition of Kani Biafran in prison in Nigeria, and that he was talking passionately about that while they were swimming together in Devon last summer. Who will be taking up that case in his stead? And B says that I'm not a lawyer, but I work closely with Jonathan at the ICO, and as a result, they became friends. And she's also asking for a copy of the special edition. But so I don't actually see any questions per se to the panelists. So I encourage people, if you do have any questions or any further comments, please put them either in the Q&A or in the chat function, both of which are at the bottom of your Zoom screen. Kana has suggested to me directly that, yeah, we could tweet the information about how people can obtain a copy of the journal. That's a really good idea. We'll commit to doing that afterwards. But Ed, over to you, because that's it from the chat box and the Q&A.
Well, I think it's been a wonderful occasion, and it's a wonderful series of articles about Johnny, and thank you to all the contributors, to Kevin, to Paul, Richard, to Leo, to Stephanie, and Madeline. It's truly a privilege to be chairing this. Johnny was my pupil, but as I think I've said, he ended up teaching me more than I taught him, and that remained the case throughout life. And as people have said, his commitment to human rights arose from his love of people and his great respect for what he talked of so often, the human dignity. I used to think, oh, that's rather vague and difficult concept, but the more I think about it, the more it sinks in as an absolute foundation of all human rights. And I think that was something that, again, that Johnny taught me, and taught us all. So he never gave up. He never despaired. He did, as people said, get very angry when there was injustice. But I think that his message of hope even against the odds, and of perseverance, and his fundamental belief that people could be persuaded, and that it was worth trying to persuade even one's opponents. I mean, those are things which are immeasurably important now. And as people have said, as Leo has said, that and Madeline, there are some massive, and Paul too, the massive injustices which we've still got to work on, and terrible things going on in some of the areas, including Belarus, where Johnny made his mark. So let's, as it were, salute Johnny in this, and continue his work as best we can, and keep him there as a sort of guardian angel for us and an inspiration in the work to come. And remember, you know, his moments. It's just great that we've remembered these things, and that it's been written down. I hope one day there'll be a book, you know, that really charts his extraordinary work and his extraordinary humanity. So thank you all for attending, and I am very grateful, and hope thank OUTy Street for organising this, and Kana, who was behind, Kana Yoshida, who was behind so much of the organisation, and thank the European Human Rights Law Review for this wonderful tribute to a wonderful person. Yeah, I think with that, unless Oliver tells me there's some other, or Kevin, that some other duty to perform, goodbye, and let's all keep, as I say, the torch has passed to a new generation. Let's keep it alight with Johnny's spirit and inspiration.